Hello everyone, I am Dr. M. Sivaji Rao, Principal of Sri Prasanna College of Law, Kurnool, Andhra Pradesh. Welcome to the second part of our Constitution series, in which I am going to explain the characteristics of Federal Constitution. This series is not only helpful for law students, but also for those who are preparing for competitive exams. So, consider subscribing to get notified for more videos on Constitution. Generally, there are two types of constitutions. They are written constitution and unwritten constitutions. Written constitution is the constitution which is in written form. The provisions such as chapters, articles, clauses and schedules have been codified in a single legal document. Examples of written constitutions are USA, Canada, Australia and Indian constitutions. Whereas the unwritten constitution is an uncodified constitution in which there is no single document that contains the fullness of law. Unwritten constitutions are based on customs, traditions, conventions and some judicial precedents. Unlike written constitutions, the unwritten constitution does not have a definite shape and systematic arrangement. The example of written constitution is Constitution of United Kingdom. Now, according to the traditional classification followed by the political scientists, constitutions can be classified into unitary and federal constitutions. If the state is unitary in nature and contains the characteristics of supremacy of center over the states, then that constitution can be described as unitary constitution. All the powers of government will be centralized in one government, that is the central government. The British and French constitutions are foremost examples of unitary constitutions. On the other hand, in a federal constitution, there will be division of powers between the union and the state, and they are independent in their own spheres. Federalism believes in supremacy of constitution and independence of judiciary. For example, the Constitution of India, USA, Canada and Australia. In view of framers of Constitution, Indian Constitution is a federal constitution. Unlike unitary constitution, the federal constitution possesses some special characteristics like as follows: distribution of powers, written constitution, supremacy of constitution, independent judiciary, rigid constitution, bicameral legislation and dual government polity. Now, I will explain all the characteristics in detail. The first feature of federalism is distribution of powers. In any federal state, there should be a clear division of powers between center and states. This will enable them to enact and legislate within their sphere of powers, and none will violate its limits by encroaching upon the powers of others. Indian Federation is based on pattern of Canada. It is a dual system of government that deals with a mechanism of institutions in which there is different governments at different levels. The central government at national level and the state government at state level are empowered to legislate on their empowered subjects. For distribution of powers, the 7th schedule of Indian Constitution has laid down 3 legislative lists which enumerated the subjects of union and states. They are union list, state list and concurrent list. The first list is union list. The union list consists 97 subjects, mainly the foreign affairs, defense, railways, postal and telegraph, etc. Regarding these 97 subjects, the central government alone can legislate on any subjects enumerated in the union list. Second, state list. The state list consists 66 subjects, mainly the police, public order, administration of justice, public health, education, agriculture, etc. Regarding these 66 subjects, the state government can legislate on any subjects enumerated in the state list under normal circumstances. Third one, concurrent list. This list consists of 47 subjects including criminal law, electricity, trade unions, bankruptcy, marriage, divorce, etc. On the subjects laid down in this concurrent list, both the union as well as states can make a law. Now a doubt will arise about the leftover subjects. The leftover powers are called residuary powers from union, state and concurrent list. The union government is empowered to legislate on the residuary powers. States will have no power over the residuary powers or leftover subjects. This is how the powers are distributed between union and states. This is distribution of powers in a federal type of constitution. Now, the second feature of federation is written constitution. Written constitution means a single written document of a constitution. In a federal type of constitution, the constitution must be a written constitution. Why? Unless the terms of the constitution is reduced in written, the supremacy of the constitution cannot be maintained practically. Further, the written constitution will be helpful to the judiciary for proper interpretation of the constitution. This helps in determining the powers of the union and states. The written constitution will lay down the framework by demarcating the fundamental rights and duties of the people, direct to principles, structures, procedures, powers and duties of the organs of the government. Indian constitution is the longest constitution in the world with 395 articles arranged under 22 parts and 8 schedules originally. After several amendments, as on 2019, we have 448 articles, 12 schedules and 25 parts. The third feature of federal constitution is supremacy of constitution. In a federal state, the constitution will guide all the three organs of the democracy. The organs of democracy are judiciary, legislative and executive in their functioning. If any state violates any provisions of the constitution, the judiciary, being the guardian and protector of the constitution, will safeguard the constitution at any cost. Even the judiciary cannot function beyond the constitution and will function as per the provisions of the constitution only. This is why in a federal type of constitution, the constitution is supreme. The fourth feature of federal constitution is independent judiciary. Independence of judiciary means any organ of the government should not interfere and must not restrain the functioning of the judiciary in such a way that it is unable to do justice. The judges must not be able to perform their functions without fear or favor. The judiciary can declare any law or action of government as unconstitutional or ultra vires if it contravenes with any provisions of the constitution. In order to ensure the impartiality of the judiciary, our judges are not removable by the executive and their salaries cannot be reduced by the parliament. Next, rigid constitution. In the constitutional perspective, rigid means very difficult to amend the constitution. In the democratic state, most of the written constitutions are rigid constitutions. In a federal constitution, though the constitution is a written constitution, it does not mean that it cannot be changed or amended. Under Article 368 of Indian Constitution, there is a provision to amend the written constitution by the parliament. But in some circumstances, it is very difficult to amend the constitution. For example, the articles relating to center-state relations can be amended only if the amendment is passed by a two-thirds majority of the members present and voting in the parliament and ratified by at least one half of the states. That is why why Indian constitution is a rigid constitution. Next, bicameral legislation. Another feature of federal constitution is bicameral legislation. In bicameral system, the lower house consists of the elected representatives of people, that is Lok Sabha, and upper house, that is Rajya Sabha, consists of representatives elected by the state legislative assemblies. The bicameral legislation in India lies in the fact that the parliamentary system has to deal with the complex issues of administering and adequately responding to the tremendous diversity prevalent within Indian polity. Next, seventh one is dual government polity. In a federal state, there are two governments. One is national or federal government, second state or unit government. The federal government will work at national level and unit government at state level. The national government will have power relating to national interest and the state government powers will be confining to that particular state. These are the 7 features of federal constitution. Now, constitution, coming to this question is whether Indian constitution truly a federal constitution. With regard to Indian constitution, there are different opinions among the constitutional jurists about the nature of the Indian constitution. One view is that it is a quasi-federal constitution and contains more unitary features than federal. The other view is that it is a federal constitution with novel features adapting itself to dismissal of state governments and imposition of national emergencies. To be precise, Indian constitution is basically a quasi-federal constitution because in India the union government generally dominates and controls the state government. State government are subordinate to union government. Union government has the right to declare national emergencies and state emergencies, but broadly speaking, Indian constitution is a federal constitution. This is federalism and its feature. This is the end of the video. If you have any queries, please post it in the comment box. Thank you very much. God bless you all.